We're the moms who ask the questions, digging deep, no second guessing. From the school run to the crime scene, truth and chaos, we're the dream team. Bad Kids Club, yeah, we ride or die. Sad eyes sharp and our standards high, brought together by FKR. Now we're taking truth real far, and we're just getting started. Talk time with Amy, Boston, and Kelly, spilling facts that hit your belly. Partners in crime, fueled by conviction. Moms on a mission with sharp intuition. Talk time, we're calling out lies with caffeine, chaos, and side-eyed vibes. It's raw, it's real, it's how we vent. Leaning close, let the reckoning commence. This is Talk Time with Amy, Boston, and Kelly, where the tea is hot and the truth cuts.
Hello, my friends. Are you guys there? Who's with us today? I see my Stacy is here. I see Hate's been up in this amount. I saw Jay was in here. Danny, his trial is today at 2. And he has church bells for balls. Proud Daddy Turtle Boy. Okay. No. Hi, Melanie, love. So yesterday or Saturday, I do apologize that we were not on. Amy was packing, and I had to rest because we leave tomorrow for St. Jude. And there was nothing gonna be happening for me, so we chose not to do our Bad Kids Club show. That's right. Balls the size of church bells. So Aidan said that the pool camera is WBZ. So I have to wait till they go live. Live stream. Oh, alarm.
Wait, can you show them what I'm doing?
I'm not online.
Yes, you are.
No, I'm not on live. Hi, Polly. How are you feeling, baby? What is... No. Go away.
I'm a cup.
I'm about to have a child be kicked to the moon.
She can't.
I'm going to put that here to birdies. Yeah, I have 2 cockatiels. They never used to make noise. And then my husband decided one day to sit down with a YouTube video and let them hear birds chirping. Now they can't shut up.
Yeah, and this girl can't because she's loud.
No, and I have my brother's cat, which is another hairless cat I actually gave to him. Her name's Ellie. And I take her back to my brother on tomorrow when we leave. And so she is, hear this right now. And I went from babysitting my kids' animals to now have my brother's animal. And then we leave for St. Jude tomorrow. So that's That's going to be fun. The mob boss has started to sing. Yep. Who else saw the interview? I know Sherry did. The interview with AJ. That interview was probably one of my favorite interviews I've ever seen. No holds barred. Everything that Aidan asked for, or asked to have, AJ did. It was like, it was intense. I'm glad. It was amazing. Oh, Hate's back. She was all if you guys hear a cat talking like a really crazy, get off my computer. If you hear a cat talking like a really crazy like meow, that would be my brother's cat. So he is, let's just say, I need a vacation, and St. Jude is not the vacation that I thought I was going to get. But we're going to go for it. So, and my Ames, you might see her pop in, you might not. She is on her vacation. So, she's going to be having fun doing that. And WCB, WBC, let's see, WBC. That's crazy. It has to be it's WBZ, right? Yeah, WBZ Boston. There we go. How was your 4th of July, my friends? Did everybody enjoy the 4th of July? Yes, Amy is at a lake house. And it's her and her mom and Kaden, and I think her best friend from my childhood is with her, and she's having fun. That way, enjoy there. Ours was okay. We had to drive 2.5 hours to my dad's to spend 2.5 hours like sardines packed in my dad's little itty bitty house. Because none of us are children anymore. We are now all we're all now big and crazy. I'm trying to find Aidan's thing. So cookouts Friday, Saturday, and Sunday. Oh my gosh, that's so busy. I don't know if I could handle it. Declan, put the thing down in front of them. I have to cover the birds. They're driving me crazy.
What?
They're just so loud. Yeah. Is it time for school to start yet, guys?
No.
Somebody? 5 seizures in 4 days. That's not fun.
We're gonna have 20 seasons right now.
Stop. That's not very nice. A couple weeks ago, or a couple years, about a year and a half ago, I had 2 seizures. I've never had any before, so I understand it's very, very, very crazy. Yeah, well, that bubble bath boy is in his bedtime right now because he was balls to the wall. Let me see. I'm trying to see where it's at. If anybody else has it on, because I don't see it. Let's see what they have. Yeah.
Prosecution mentioned there was no contact from HSI or Special Agent Fernandez follow-up. During the alleged incident, Mr. Zapata exhibited no violent nor dangerous behavior when he was apprehended. He cooperated with law enforcement, as is indicated in the police report, where it says he was arrested without incident. The only words that Mr. Zapata uttered was no English to indicate his limited knowledge of the language. Mr. Zapata had no weapons on him when he was apprehended. He made no attempt to flee.
Right now,
There was no threat of violence.
on.
Mr. Zapata also has zero history of mental illness or drug dependency.
Sure, I'm trying.
And there was no hint of any kind that he was under the influence of any substance on the day when he was arrested.
How much bail can he make?
I've spoken with Mr. Zapata. He says somewhere around $10,000 or so, if possible.
$20,000 cash bail.
Mr. Zapata
Surrender
also...
his passport within 24 hours of release.
We have an next date of July 17th for probable cause.
All right.
Quincy Court, Your Honor.
Sounds good. Thank you. Nice
Thank
to
you,
see
Your Honor. So, sir, after hearing
They just hauled bail would be given.
the sum of $20,000 cash with the following conditions. Surrender your passport within 24 hours of your release. Consent to that condition, sir?
Thank you.
Yes. Thank you.
Thank you.
You're hereby notified if you charge with a crime during the period of your release, your bail in this matter may be revoked in accordance with Mass General Laws, Chapter 276, Section 58. Thank you, sir.
Thank you, Your Honor.
Thank you. Have a nice day.
Your Honor.
Nice to see you.
Welcome.
Mr. McCray, always a pleasure.
Thank you, Lyle.
Take care.
Good to be back.
Are we ready
Good to be back.
on the Kearney matters? Okay.
Guys, don't forget to go. We're on a
This
list.
one?
We're going to do Mr. Kearney. So next before the court, number 6, 7, and 17. Number 6 and 7 are on for status. Number 17, which is 25 CR 88, is on for arraignment.
So make sure that you guys go
Forward and
over
identify yourselves for the record.
like the young jerks.
Good afternoon, Your Honor. Robert Cosgrove for the Commonwealth.
Good afternoon.
Hello, Your Honor. Timothy Bradle on behalf of Aidan
Only
Kearney.
way they
To
were
my
gonna
left.
be able to
Good
see-
afternoon. Good afternoon, Mr. Kearney.
And Mark Federer for Mr. Kearney.
I'm Mr. Bedero. Good afternoon. Okay, let's arraign him on the new case.
Mr. Kearney, on May 13th of 2025, the grand jury sitting in the County of Norfolk returned indictment number 2582 CR 00088, charging you as follows. Offense 1, charging intimidation of a witness, and offense 2, charging intimidation of a witness. Do you wish to waive the formal reading of these indictments?
Yes.
How do you wish to plead to each of these indictments?
Not guilty.
Thank you, sir.
Okay.
Is there a question of bail?
There's no question of bail, but I would ask the court to impose the same conditions that were imposed in the Stoughton District Court. And Mr. Bradle, correct me if my memory is wrong. I believe it was no contact with the alleged victim and stay 100 yards away from this place of work and residence.
And what are the allegations on these, on this one?
Intimidation of a witness, Your Honor.
Yeah, but what's the nature of it?
This was the appearance outside.
Oh, outside the, waving in the pizza shop. Yeah, I remember this. All right,
Judge, that's agreed under Section 87.
yeah, that's fine. All right, I'll impose that, Margaret.
Thank you.
Would you like me to do that now or wait till the end?
Why don't you do that now? Just do them one at a
All right,
time.
the court recognizes you personally without surety with the following conditions. You are to have no contact, direct or indirect, with the victim in this case. You are to stay away, have no contact, stay away 100 yards from the residence and the place of work of the complainant. Do you assent to those conditions, sir?
Yes.
You're
Okay.
hereby notified if you're charged with a crime during the period of your release, the bail in this matter may be revoked in accordance with Mass General Law, Chapter 276, Section 15. Thank you.
All right, what else are we gonna do?
Judge, if I may jump in right there, just for the record, we filed 2 arraignment-related motions, Your Honor.
Okay,
Obviously, we can push those to another day with 2 small exceptions of just an order to preserve notes of investigators and to preserve video, if I may, Your Honor. I don't believe there's an objection.
okay. Yeah, those are both ordered. So
Thank
we saw, the Commonwealth's ordered to preserve notes of investigators and to preserve video. What else can I do for you?
For me or?
Why don't I start with you, Mr. Cosgrove? Go right ahead.
All right. So Your Honor, answered a discovery order the last time we were here. I made substantial progress on it. I can't say I fully complied with it, but I have about, let's see, somewhere in the neighborhood of 5,000 or 6,000 pages of discovery to provide Mr. Bradel today. And I had planned, Your Honor, to file that with a motion for a protective order, which I had served on Mr. Bradel a couple of days from the one I gave you.
Thank you.
And we have been going along with these, essentially tracking protective orders in the Karen Reed case, and in fact, much of the material is duplicative of discovery turned over in the Karen Reed case, and I pretty much followed their form protective order. These have all been allowed with the agreement of the defendant and without prejudice.
Okay.
I understand that Mr. Bradel wishes to bring that practice to an end as of today. I'm in a somewhat different position.
All right, let me hear from Mr. Bradel. Mr. Bradel,
Thank you, Your Honor.
give me your argument.
I appreciate it, Your Honor. Judge, the Karen Reed case is over with. It's moot. It's gone, okay? And my filing, Judge, entitled Aidan Kearney's motion to release case documents from impoundment is what we're talking about here, Your Honor. So I asked the court last time, and we had so much business on the docket last time, I don't think we circled back on it. But I was asking to just release everything from impoundment, Your Honor. The fact that things are embarrassing or scandalous or cause negative light to be cast upon public officials, Your Honor, is not a reason to impound documents. It's actually a reason to release documents. And that's really all the Commonwealth has left on the existing stuff, is that, gee, this might make investigators look bad. This might make special prosecutors, present company accepted, look bad. This might, cause election shifts, and that's not a reason to impound things, Your Honor. And initially, we have sort of taken the candy from, from the Commonwealth, and when they say, we'll give you the stuff, but just agree to this protective order. So we want the stuff, but at some point we have to get off of that train, Your Honor. This is a case of immense public interest. This is a case of, First Amendment issues, and I know we may disagree on that, but that's what our adversary system is for, and that's okay. And I think every case that eventually gets to the SJC or the Supreme Court starts with a trial judge maybe not agreeing with you, so that's okay. And, that's what we have here. But in any event, Your Honor, I think court, but we all know what they say, and we all know that there's a public interest in shining some sunlight on these things. So we're not asking to, publish someone's.
Mr. Doucette.
Very good, Your Honor.
Good, nice to see you.
Yeager, she's a V
How are you?
303 intern.
Great.
Good morning.
She was just here.
Yeah.
Okay.
Did 20 minutes ago a fairly extensive motion suggesting that I have all kinds of various burdens to justify impoundment and citing a lot of case law. I would like an opportunity to file a written response.
Yeah, I'd give you that. Was a week enough?
I'd like a little more than that. Your
About
Honor.
2 weeks.
All right.
There you go. I'll give you 2 weeks. I'll take it under advisement. And if you want to file anything else, Mr. Bradel, Mr. Betterow, you absolutely have every opportunity.
Thank you very much, Your Honor. And
Now, Your Honor, with respect to the items that I was going to turn over today,
So I'll allow the motion. Mr. Bradel, I'm up here.
sorry, Your Honor.
It's all right.
I thought I had a minute.
That's fine. You got to talk to your client. You got to talk to Mr. Betterow. My point is this. If you want the stuff today, I'll allow it without prejudice.
Sure.
And then I'll see what you have to say and what Mr. Cosgrove.
We have to take the candy.
That's fine.
All right. Please note our objection, but thank you.
Yeah, no, that's fine. So I will allow Mr. Cosgrove's motion without prejudice, and I'll take any submissions that you have, and I'll give you a final answer probably in about 3 weeks.
Thank you very
Does
much.
that make sense? Okay.
And then, Judge, just to shift gears a little bit, there's some outstanding discovery that we've been talking about.
Yeah?
And I want to start off, I know that the court's time can be much better spent in discovery disputes. So we talked about the idea that we would go to the DA's office, and to the extent there's items that the government says they've given us that we can't open up or figure out,
Yeah.
I think we're going to agree to go in person with our people and figure it out. So
Yeah, sure.
that's the first thing I want to say. But then, in addition, Your Honor, there's this inventory that I filed. It's entitled Inventory of Outstanding Items in Connection with our Third Motion to Compel.
Okay.
There's about 10 things, Your Honor, and I think, unfortunately, that the government ought to go through and answer to us today about what the status of these things is. And we've been kind of going back and forth about these things for a long time. I looked back, Your Honor, and my first discovery request was February of 24. And second and third, were the months following. And in fairness, counsel for the Commonwealth was not the prosecutor of record at the time. But, the rules are the rules, and we need this stuff, and it's gone on way too long. So these are the 10 things that I think are very important, maybe 9.
Mr. Cosgrove, might you want to take that 2 weeks and respond to all of those?
could you give me an extra week, Your Honor?
An extra week.
Thank you.
All right. But it is, Mr. Bradel makes a very good point. As we all know, I think that it's important that the discovery be turned over so that we can bring a timely trial to the case.
I don't disagree with Your Honor. Notwithstanding that Mr. Bradel has some complaints, and some of them may well be legitimate, there has been a substantial amount of discovery turned over in this case.
Yeah. If you turn over 5,000 pages today, it's a lot of discovery.
We appreciate it, Your Honor.
Okay, great.
Thank you. And Attorney Betterow has a number of items as well, Judge.
Mr. Betterow.
Thank you, Judge. Just going back briefly to some of the issues about impoundment.
Yeah.
There are some items that are currently under impoundment, which we believe ought to be released from impoundment, specifically messages from Michael Proctor and a civilian witness. Those messages were cited in our motion to dismiss. As the court is no doubt aware, Michael Proctor is terminated from the state police. He has been a matter of public interest with his involvement in both the Karen Reed case, which led to Mr. Kearney's interest and ultimately, on some level, his indictment in this case. But also, those messages were impounded ostensibly for privacy interests, security interests, those sorts of things. Recently, Michael Proctor has been on a press tour on ABC News and NBC News, vigorously defending his investigative conduct. The messages that are at issue here, which are impounded, the public is entitled to see that. There is certainly a presumption of public access to those files. Michael Proctor has surrendered any privacy interest he has by addressing those issues, as has, the other civilian that we're talking about, who also recently appeared on national news with other members of her family defending her and her family's conduct in this case. Those messages should be publicly available. If there's going to be information that's in the public realm, there's no reason why information that the prosecution wanted concealed from public view should be concealed any further. If the court likes, we can approach and show you the messages. I would suggest they are relatively straightforward, and there's no reason for those to be impounded at this time.
Okay. Anything you want to say to that, Mr. Cosgrove? I'm not going to give you another week.
Well, I would suggest it would make sense to take this up when we take up the other matters.
I think that makes sense too.
Yeah, I won't ask for another week. I won't ask for another day.
That's, why don't I do this? Why don't you all come up the sidebar? Let me take a look at what you need.
I'm having trouble finding, I was trying to find the login myself. So I shared Mike. Hopefully he won't be upset with me. I'll message him and let him know that I did. I can't, I don't know why. It's been a rough day today. I don't know, guys. He said it was the WBZ camera. But WBZ did not come on. So it's obviously a Zoom camera. Let's see. .gov also redid their stuff.
You go back. Mr. Betterow, the floor is yours. What else?
Thank you. Judge, one outstanding issue relates to the second of the three indictments that relates to Lindsay Gaetani. We moved and were granted a hearing to disqualify Mr. Mello from prosecuting that case because he is an essential witness in that matter. That issue was decided in September of 2024. A hearing was ordered in January of 2025. For reasons which the court is familiar with, that hearing has been put off. Nevertheless, we're looking to move this forward, and the issue is not resolved, and we're led to believe that Mr. Mello will not voluntarily withdraw. For whatever reason, we need to do this hearing. We believe that he's going to be a defense witness in this case. We're getting discovery between him and another civilian witness today, which I think is going to further that application and very likely make him even more a prosecution witness. And we just can't kick this can down the road for close to a year. So we would like to schedule a date for Mr. Mello to either appear, be examined under oath, explain the consequences, which the court, again, is probably familiar with. He was contacted by the complainant during the alleged crime repeatedly, 4 or 5 times over the course of that day. Instead of the police being called, he was an ear witness to these allegations. Respectfully, he needs to come in here, answer these questions so the court can issue a decision as to whether he's going to be allowed to continue or whether we can go through the process of subpoenaing him and any other items that might be of assistance to us with calling him as a witness.
Mr. Cosgrove.
Could I inquire if Mr. Mello is online?
I do not see him. Attorney Mello, last time he did use his name, there is no one with his name on there this time.
Can I approach?
Of course. Come on up.
Thank God he didn't.
Hi, Mary.
Oh, is that him? Texter. Teamster. Wait. Is it? Oh my God! Yes. What?
Mr. Betterow, you said you had one more thing.
Yes, Judge. Just as it relates to discovery, we have made a series of discovery demands from the prosecution ranging from October of 2024. As of this date, not including whatever was filed today, we have made 4 very thorough, detailed discovery demands sourced regarding contacts between a civilian named Catherine Peter and the state police and the district attorney's office regarding her very unique relationship in all matters involving Mr. Kearney. Those demands, which again are in the files, Mr. Cosgrove has them outlined in detail, her frequent contacts with the state police, with people that are prosecutors, statements that she has made under oath in court proceedings stating that she helps authorities get Mr. Kearney, voice recordings that she has left Mr. Kearney indicating that she provides information to them. So we have asked for any discovery related to Ms. Peter going on about a year. Now, today, for the first time, we are admittedly getting something that relates to her communications with Mr. Mello. I'll only note that all materials that relate to Ms. Peter and the prosecution were ordered by the court in early May to have been provided within 20 days. That didn't happen. We got stuff today. That's fine. But the real issue here is that in light of the change in Rule 14 from last March, the game is very different than it might have been before in terms of what the prosecution is obligated to do and what I don't believe they've done in this case, which is go to every member of the prosecution team, which is everyone in the district attorney's office, any of the state police who are involved in these matters, which includes Michael Proctor at the time, Yuri Buchanan, Lieutenant Tully, Fanning, there's a whole list of them. The Karen Reed prosecutors who are also covered, who got a little bit involved, as the court is aware, in Mr. Kearney's case and may or may not have had a relationship with her too. She has made statements allegedly indicating some involvement in that case. The rule requires the prosecution, whether they credit the information or not, to contact each individual that is on the prosecution team and make an inquiry and find out whether there is any material and disclose it. We don't think that that has happened. We respectfully submit that is something that Mr. Cosgrove has to do. In particular, I would draw the court's attention to testimony that was given by a member of the state police in February of 2024, which led to a wiretapping charge against Mr. Kearney, in which Fanning of the state police stated under oath that they received a recording, a 30-second recording from Catherine Peter, that it was given to Lieutenant Tully and then given to Fanning, and we have no evidence of that. We don't have a copy of the recording. We were given the wrong recording in that regard. We have no police reports. We have no communications. We have nothing. If they don't exist, they don't exist, but they're obligated to look for it, make the inquiry, and report back and say whether any of this exists or not. And the last thing I'll note on that point, under the new rule, it doesn't matter whether the prosecutor credits any of this, thinks it's nonsense, thinks it might be real, they're obligated to do it. And we simply ask respectfully that the court instruct the prosecution to do that and disclose whatever evidence ought to be disclosed, or make a statement on the record that there is nothing to disclose. And if that's the case, then we'll all live and die with the consequences of that statement.
Okay, Mr. Cosgrove.
It's largely been done.
Is that part of the 5,000 pages that you're turning over?
It is. Among the things turned over is the email from Catherine Peter to Brian Tully providing that 30-second clip.
Gotcha. Okay, that's fine. So that seems to solve that. You said that you had some things you wanted to bring up. Go right ahead.
Yes. So this will be an opportunity, Your Honor, for myself and Mr. Betterow to do an absolute 180 on our positions on disclosure of impounded documents. Your Honor will recall that the last time we were here, attached to a discovery motion was an affidavit.
Oh, yeah.
And at that time, it was initially filed provisionally without hearing from the Commonwealth, was impounded upon, I believe, not the affiant's representation, but I think Mr. Bradle's representation that the affiant was in fear that there would be some sort of retaliation by the Commonwealth. I think Your Honor will recall the fairly outrageous, if I can put it that way, representations that were made by the affiant. I believe now, as I moved at the time, that affidavit should either be stricken or that the impoundment order should be lifted. I don't believe an affiant should be allowed to accuse an assistant DA of jury tampering and the district attorney of having secret meetings with witnesses and all these other things, and then hide behind an impoundment order.
Okay. Let me hear from the other side. Mr. Dedham.
Yes, a couple things that I think ought to be corrected. The affiant is not alleging what happened. The affiant is alleging under oath that she was told by another individual who we were discussing earlier what happened. That's the first point. The second point is that document was attached as an exhibit to a discovery demand. Discovery demand number 4, alleging more reason to believe that there is an obligation for the prosecution to look into possible discovery that is in their possession, custody, or control. If that affidavit were to be stricken, that means literally nothing. They are still obligated to do whatever it is they had to do. And at the time that that motion was discovered until 20 minutes ago, absolutely nothing has been turned over regarding this person who brags about working for the authorities. So I don't know the relevance of doing anything one way or the other with respect to the affidavit. Now, that person may very well have a privacy interest because the day after that affidavit was filed, her apartment was essentially covered in personal information about herself that could have only come from someone with access to law enforcement. And almost certainly that individual was subjected to charges of witness tampering, which I believe were actually under investigation and may still very well be. I can't go farther than that. I don't know. Somebody, whoever did this, wrote snitch on her door. So I would suggest in this situation, impoundment of her name is more than appropriate.
Okay.
Just make 2 points in response. One, I don't think it's entirely true that the affiant was simply relying on recounting hearsay. If she was, that would say something about the credibility of the affidavit as well. But I seem to recall, Your Honor, that at least one point the affiant represented that she was present when Ms. Peter, I believe it was having a phone conversation with Hank Brennan, and that she, the affiant, recognized Hank Brennan's voice because she was familiar with it. So I don't think it was simply a matter of hearsay. The second thing I'd say is that the identity of this person is all over the internet, and was all over the internet at the time it was before you the other day. I don't know what the interest is, given those circumstances, in concealing it in the court papers.
Okay. Judge, I'm sorry,
and I'm sorry.
I'm sorry, go ahead.
Could I just add one thing?
Yeah, go ahead.
Apparently these things that were affixed to her door in her apartment building, which is the same apartment building that Ms. Peters lives in. And I think the implication was made at the time. First of all, that event was publicized by Mr. Kearney on the internet with photographs of the door in question. And I guess I would just question, Your Honor, the source of those documents, let's put it that way.
Okay.
Just very quickly, Your Honor, in terms of this individual's name being on the internet, there are 2 reasons for that. The first is because Ms. Peter identified her publicly and led to this kind of harassment. The other reason, and this was no question a mistake, but Mr. Cosgrove mentioned her name accidentally, and no question, no malintent, but her name was stated in open court, and as you can see, people watch in court, online, and whatnot. So the fact that her name had been put out accidentally through no fault, with no malintent, is not a reason, I think, to just open up the affidavit to her name.
Okay, thank you all. So we have a date for, what was that, August? What was the date, Margaret?
August 13th for
August
discovery
13th.
compliance.
And then we'll pick a date for the other issue. Am I correct, Mr. Cosgrove?
Yeah.
Towards the end of the month?
Now, or do you want to pick it on?
Why don't we pick it on the 13th? I think that makes sense.
All right, I may have some, I'm sorry, I should be standing.
That's okay.
I may have some information about,
That's fine.
the health status at that time.
All right. We'll see you all on August 13th.
Thank you.
Okay, thank you all.
One more, Your Honor.
Go ahead.
Oh, sorry. I believe we have an agreement. Mr. Bradel has responded relative to the source code for accessing the search of the devices.
Yep.
And he's indicated it was the same source code previously provided Lieutenant Tully, and that he would supply it again if necessary. And I've indicated to him that that's appropriate, and I think he should supply it today.
So
and I
Mr.
don't think
Bradel-
there's a disagreement with that.
All right. You don't disagree with that, do you?
Sure.
Yeah, all right, good. I'll see you August 13th.
Thank you.
All right, take care. Bye.
2 p.m.
2 p.m.
Thank you. I'm trying to turn the heat on.
We have any lobbies we could go?
Yeah, we're gonna take that. We'll take it across the
Yes.
street.
Yeah.
Get out of it. Just get out of
I'm
it.
not aware that, I'll check on that. I know I saw something where she said in a text message to this Jean lady, this message she said, thank you.
Thanks.
Yeah. Yeah.
Okay, next before the court, number 18, Como versus Lokeshwar Chintak Kunta. I apologize for that pronunciation. The party.
I think. Yeah, I'll find out.
Okay, so what I will probably do is take it off of X. I just don't want to get dinged from Mike, which I don't think that he will. But I do have some other news that we haven't seen yet. Let me see. Hold on. Let's do my profile first. Okay. Look at this fancy smanciness, you guys. I appreciate you guys. Thank you. I wanted to make sure we heard it, and then I couldn't find the Zoom, and I was freaking out. So, hopefully we'll be okay. But, Miss Laura Owens, you know, crazy girl. She's a crazy girl. She's the one that pretended to have twins from a blowy, and they are going after her hard, and they are throwing the book at her, and they are going to be making an example out of her, I believe. She says here from Snitchel Ninja, Laura Owens mugshot. She was indicted in Maricopa County on 5/27 on 7 felony accounts. What they did with extenuating circumstances for this is they made sure to go find her the other way. They made sure to put on there that they wanted major consequences. They were trying to make sure that even though there's 7 county felony counts, they're not together. It's all each separate, and there's seven different felony counts. And there's also been in the paperwork that she had an accomplice. So somebody, I don't know who, probably her mother, is getting is being looked at as a co-conspirator or an accomplice. So, and I know that Miss Laura is, trust me, Christine, we'll be covering Miss Laura Owens. You want to talk about crazy? This girl is crazy. This is one I wouldn't want to be around. But I'm so glad Clayton won. She still put her stuff in for appeal. They did not, let's see what it says. There's her indictment. Let me see. July 3rd, Laura Owens' family has been hit with another lawsuit. The Fate pregnancy scanner who continues to report me for cyberbullying despite the considerable increasing restraint and not calling her a cunt on live stream. Chivalry isn't dead, fam, and apparently it has sketchy financial woes going back decades. I'll have much more to explain. So they're being sued again, and that's by JP Morgan Chase Bank. It's civil litigation against Ron Owens, her dad, and her mom, which, if you know, her dad is sick. Her dad is pretty sick, and he has a GoFundMe up, and they're trying to get the GoFundMe for him, but they have money. So where's the money going? They're basically paying for her charges and everything else. So they're trying to raise the money, not for him being ill. It's for her, even though they're full of it. And then, so here is, if you want to go down a deep hole, you can. This is her indictment and her criminal charges. There's a couple websites you can go to. There's justiceforclayton.com. There is the Justice for Clayton Reddit page. There is Justice for Clayton. Another one called All the Best, I believe. It's on X. Let me see what it is. All the Best Research. So this is another page of hers that you can go down this hole. And All the Best Research, it says, like on May 12th, it was saying that Laura Owens transfers assets, removes business affiliation following nearly $150,000 judgment in the paternity case. So she owes Clayton about $180,000 with all of the cases that she's lost, and she put it in for another appeal. And they have a whole Substack, and there is a Wikipedia page on her. There is, I would do a whole story on her today if I could. I just don't have it in me to do it. I'm too tired. But that right there is probably one of the I know there was a justice for Clayton. Let me see if it's still there. So I've been watching this one since the beginning. She actually gave him a dating contract. But there's other men that are involved in this, and yeah, there is a justice for Clayton Wikipedia wiki site they made, and has everything. Like, this has the entire timeline on it, so you could let me see. This actually goes into detail of how everything started. Clayton Eckert starred season 26, The Bachelor, had a one-night fling, allegedly just oral sex, with Laura on May 20th, 2023, 11 days later. After he refuses to pursue a relationship with her, she claims she is pregnant. She drafts a dating contract to give Clayton, stating that she would abort the baby if he agreed to date her, but he still refused. On August 11th, she took him to court to establish a parenting plan for babies, now twins, and set upwards of 500 emails and texts to him, more than a dozen different accounts. She went public with the case in September when he still refused to date her. She claims under oath on November 2nd that she was 24 weeks pregnant and had just seen her OB a few days prior. Laura and Clayton are both granted orders of protection against one another. As of September 28th, she claimed she was no longer pregnant and sought to dismiss the court cases because Clayton believed she fraudulently brought the situation into court and did not have evidence to prove that she was actually pregnant. And he refused to let it go and sought the attorney's fees. On June 10th, there was the evidentiary hearing that they had. It was a 2-hour hearing. This is when her lawyer was doing baseball signals, all these baseball signals to like tell her to stop, and got caught. Yes, this is the one that Omar went over a couple weeks ago with us. And he's going to come on more, and we're going to want on his show more because Omar and I have become pretty good friends, and I enjoy having him on and having, Bruce on and just everybody learning. And then Lauren Knighty is another one. She's the one that said that there was more charges coming out. She's going to be coming on with us as well. Mind-blowing. Christine, you're right. It's mind-blowing. Like, there is no way to describe Laura Owens. The only way that she is going to stop is if she gets put jail time. If they just give her probation, it's never going to stop. She's already done this to at least 4 men that we know of. And Mike Maricini is just, yeah, Lauren Knighty is court of random opinions. Lauren Knighty, and this woman is going to keep doing this if they don't stop her by doing it now. And Clayton's first one that stood up to her and said, no, we're not doing it. Hey, Crafty Chris. And so this one actually has the timeline of events that you can go on and see. It says like April 3rd, he announced on Instagram that he was a real estate agent. On May 9th, she created an LLC for the purpose of real estate and renting and leasing. On May 17th, she reached out to Clayton on LinkedIn for his assistance. May 20th, after some flirty texts and a racy photo sent by Laura, Clayton invited her over and they had an intimate encounter. And the following day, when Clayton told her that it was a hookup was a mistake, May 21st, Clayton makes his intentions clear that he does not want to pursue a relationship with her and apologizes for crossing the professional and personal boundary. She breaks down in tears, refuses to accept it, and asks him to continue to be her realtor. Stop. May 22nd, Owen starts telling Eckerd that she cannot continue to have him be her realtor if he doesn't want to pursue a relationship. He consistently tells her he will assign her to another realtor, but she will not accept. Clayton asks Owen to leave him alone, informing her that considering contacting the police, and blocks her phone number. On the 30th, Laura states she took a pregnancy test before a CT scan and it was negative. May 31st, she said she took a home test and first it stated negative, but then it had a faint positive. And so she decided to get another one done. She says she went to Banner Urgent Care and tested positive 11 days after their intimate encounter, which is now known that she was getting HCG injections by a weight loss clinic that somebody was helping send it to her without her name being involved in it. So those are just some of the things, how it starts to get you hooked. And she has a dirty dish rag is a nice way of putting it. And the problem, she has this, and she has Greg Gillespie, who is also in Arizona. And then she has Clayton that she did too, but she also has Mike Maritini. And she does not like that these men have become friends and support each other. So it actually bothers her a lot that she... Guys, Daddy walked in the door and the dogs went crazy. So yeah, she is, let's see, I have a picture. Oh my God, he's crazy. Hi baby, how are you? I'm trying to find a picture. I have a picture of the three guys together that I would show you guys if I can find it. Sorry about the loudness in the house, the dogs. Daddy snuck up on them. They did not expect that to happen. Oh, and I can't seem to find it, but I do. Let's see. It's probably because it's all here. I'll find it later. I'm not stressed about finding it for you guys. I know you guys will want to watch it or see it, but I'll find it for you next time. I wanted to, yes, my oldest children are back from Alaska. And they came and got their dog. And then my brother came down to visit from New Jersey. And apparently my brother is the only human who brings his cat and his dog to drive 24 hours straight to Florida and guess who got the cat, which is fine because she used to be my cat and I love her. I gave her to him for my niece for her anxiety, but it was just stressful. I do want to show you guys something. Hold on, I gotta get it. Oh, I have put it down because they were so loud.
Oh, yeah.
Oh, here we go. Okay. Are we ready? I'm gonna pull my camera up there and I'm gonna show you guys. Don't look at me. So look at the baby hedgehogs. They're not so baby no more. They're big babies. It's a big baby, huh? So I did it. I was able to save them and I fed them from a week and a half old This is just one of them. I have two more. This is just one baby. And he is the sweetest thing in the world. They all are. So if anybody's looking or knows anybody who wants to look for a hedgehog, these are probably your best bets of ones that are as sweet as they are. Aren't they big? Oh my gosh. I should get you the other one. Hold on. Let me shut my camera off. I'll get you the other one. Because there's two more. Let's see. Okay, so this one he was the smallest, or she was the smallest baby. And so she's got more of the lightness around her edges. Oh, girl, yeah, Danny, we're covering it. We're going to be all up on that. So if you guys don't know the story of the hedgehogs, I didn't breastfeed them, but I syringe feed these babies. They were a week and a half old. Their mother rejected them. There was 5. I lost 2, the 2 smallest ones, but now they're almost 8 weeks now, and they are big old babies. Big old babies. Yes, they do not like to ball up either. Most of them, like, that's me kind of holding them, but he's like, nope. Let's see. Yeah, right now he's soft. Right now he's good. The only time if he gets upset or scared, he'll push his quills up, and those can get painful. But even at that, like, if you know how to handle them, you're fine. But these babies have been hand fed from the beginning, so they are spoiled little rotten baby girls is what they are. So it is, yeah. So it just, the spikes come up when they're scared, when they're annoyed, and, like, sometimes they'll pop up, like, with their spikes up because they want to, like, protect themselves. But these 3, I have another one. Let me grab the other one. You guys can see her. Let me see. This one she is what's called she's a reverse pinto. And so she's got a little black spot on her. And then she's a cute one. But they're all just, they're eating regular foods now. They're, see, she's balling up a little bit for you. They're eating regular food, and they are, say hi, baby. You say hi? So not the little things I showed you in the beginning, huh? I know you were asking to see on Hate, but yeah, they're sweet babies. Sweet babies. So if anybody that wants to purchase a hedgehog, that's probably going to be one of the best you've ever had in your life, because they've been handheld and fed since they were a week and a half old. I was up every 2 hours with them, feeding them. I was tired. I slept on the couch for 2.5 weeks, and then they're heavy. They're not little itty bitty things anymore. So I'm so proud. I'm proud of myself. I did it, because it's not an easy thing to do, and a lot of people can't do it. So you got the baby girl. Oh, so that's the babies. It's an update on the babies. I'll focus more when I get back from St. Jude this weekend. Focus more on getting putting them out there and putting them on for sale. I think they do have transport companies. I have had hedgehogs transported to me from Alabama. I've had them transported me from South Carolina. It just depends on. One of them is called Road Dogs, Lillian. She's one of my favorite people in the world. But there's another one. I have to look at the name. I have them on my Facebook. They are a little bit cheaper because they pick them up. They have a route that they go, and they just add you to their route, and they pick them up as they go. So it could take a little bit longer to get to you. It's not like they're picking them up and bringing them straight to you. There's also a thing called Citizen Shipper, where you can go on and say what you have, and they'll transport that way. I've used that too. So in Massachusetts, they are legal. There are a couple states, not many. They will be ready to go in the next week and a half. So probably next week sometime they'll be ready to go. So they are amazing. They have been amazing. They have made me realize what I can do, which is not a lot, but I could save some babies. So, all right, guys, thanks for joining us, for watching Aidan's trial, and I'll be back, I guess, August 13th is the next one. But I do know that Kate Peters has a trial coming up on, let's see. Kate Peters' trial. Where is it? There she is. It's coming up on July 30th. It's her, it's a motion to dismiss. So we'll see what happens. It's when KP flipped off Lauren and Aidan and was yelling obscenities at Lauren. And then the other one is, I don't know if you guys heard, but we have Rogue, if you guys know of him. He was served with a witness intimidation summons, and he was charged with felony witness intimidation. And he is scheduled for August 4th for his arraignment, and it missed probable cause. They went straight from probable cause, and that is hooked to the Lindsay Gattani case of her big victims case. So that one's a good one as well, and that one's August 4th. And I have a feeling that Lindsay Gattani might be getting more charges based off of his, because he is the one that wrote a character reference letter for the court for big victim. And now he's the one getting witness intimidation charges. So just say a prayer for that, and that it goes through, and that he gets in trouble, because I'm sick of seeing Aidan go down for them trying to keep him quiet when everybody else is getting the same thing. And how many witness intimidation charges have you got out there? And it's so stupid, and it's just trying to silence people. But I just want everyone know. So we'll see you guys. Amy is on vacation this week. I leave tomorrow, so there probably won't be anything during the day except for today, because I'll be at St. Jude, and we have appointments, and we're driving. So then we will end up, but Amy and I are talking about doing a nighttime episode while we're there. So I'll be at St. Jude doing it, and she will be at her vacation, and we were gonna do one and kind of just go over Diddy and all that stuff. So But we will talk to you guys soon. We love you. Mwah, mwah, mwah. And we will stay in touch with you guys. So just keep an eye on the page, okay? All right, bye.
How am I supposed to say that? Talk time with Amy in Boston and Kelly. Time with Amy, Boston and Kelly. Talk 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 time with Amy, Boston and Kelly. Is a member, y'all. Is a member, y'all, to the Gene Deal Show. Talk time with Amy in Boston and Kelly. Talk time with Amy, Boston and Kelly. Talk time with Amy, Boston and Kelly is a member to the Gene Deal Show. Oh, thank you for your membership. Talk time with Amy in Boston and Kelly on the Gene.